You're still watching Good Morning Nigeria. We're reaching you from the Nigerian Television Authority. As a prompt for our conversation this morning, which is on conflicting court orders and the implications for Nigeria's democracy, let's take this background report by Joseph Orten.
The judiciary is said to be the last hope of the common man, but when the court, which is a vital component of the judicial system, is found conflicting itself, the citizens cannot help but to look with despair. The recent conflicting court orders issued by judges in different states of the country in respect to the National Party chairmanship of the People's Democratic Party has once again exposed weaknesses in the country's judicial system. In 1 week, 3 court orders were issued, either restraining Uche Secondus from parading himself as the national chairman of the party or reinstating him, while a Rivers State High Court granted an interim injunction restraining Secondus from parading himself as national chairman and member of the PDP. A new twist took place in less than 72 hours as the embattled chairman of the party obtained a court order from a Kebbi High Court reinstating him. Few hours after that, a High Court in Cross River State sitting in Calabar again restrained Uche Secondus from functioning as the national chairman of PDP, pending determination of the suit. The crisis surrounding last Anambra governorship primaries is still fresh in the minds of many. The recent conflicting court orders across the country has called out the National Judicial Council to intervene and save the judiciary from ridicule and distortion of justice. The statutory body concerned with the appointment and discipline of judges has summoned chief judges of 6 states, Rivers, Kebbi, Cross River, Anambra, Jigawa and Imo states to face interrogation over the wave of conflicting orders issued from their courts. Meanwhile, the Nigerian Bar Association has also expressed concern over indiscriminate grant of orders and counter orders, describing it as a threat to the nation's democracy. As the NJC keeps trying to cleanse its house, questions of professionalism and integrity of many judges continue to linger, while Nigerians ponder on the fate of the nation's democracy and its fight against impunity. Guests on Good Morning Nigeria will, in a short while, give perspectives on this development.
Thank you very much there for that background. We have 3 guests with us this morning. 2 of them are senior advocates here in the Abuja studios. Mazi Afam Osigwe, learned senior advocate of Nigeria and former Secretary General of the Nigerian Bar Association. Mazi Afam, delighted to have you again on Good Morning Nigeria.
Thanks for having me.
Also here with us in the studios, a regular on Good Morning Nigeria, Frank Tietie. He's a human rights lawyer and executive director of Citizens Advocacy for Social and Economic Rights.
My pleasure.
Good to have you.
My pleasure, indeed.
And also joining us from our Kaduna studio is Yunus Ustaz Usman, senior advocate of Nigeria. And thank you so much for joining us, Ustaz. And thank you so much for joining us, Ustaz. Thank you so much. I was having a little problem when I went through the script in the morning with the name you mentioned.
Oh, okay. Frank Tietie. But it looks like we're all of us, we're all having a shade of gray or direct gray, including learned senior advocate Yunus Ustaz Usman, who is a regular also on Good Morning Nigeria from Kaduna. Well, for the benefit of a majority of our viewers, we'll probably need to take this step by step. Just, if you like, an elementary breakdown of what appears so confusing to those who are not lawyers, so that we have an understanding as to why perhaps all of this is happening and what is being sought after. I don't know. So you may just be patient as we just go through a few steps, in the legal classroom. But we won't get into the details of the equity of injunctions and the classes of injunctions and so on and so forth. But gentlemen, beginning with here in the studios, Mazi Afam Osigwe. The ordinary folks get to read about this. I mean, the latest instance is what we are seeing with the PDP, whether the chairman should go or the chairman shouldn't go. One court issues, another says vacate the seat. Another one says, hey, no, stay put. Another one says, no, you must go. In the case of the Anambra governorship election coming up in November, unless you are indeed an interested stakeholder, you would have lost interest as to who is actually the flag bearer or the standard bearer, as it's often said. In the election, one point is, Soludo, you are not in. Another one says, no, you are in, and so on and so forth. How does the ordinary citizen make sense of this?
When you talk about the ordinary citizen, it suggests that the not ordinary citizen, or even lawyers, understand what is going on. But I think what is going on is best summed up in the comments made by Honorable Justice Nwosu Iheme of the Court of Appeal, Local Division, that politicians are going around Nigeria shopping for others, and that senior lawyers are aiding them in this. And so people want to put the judicial process to the wrong use. And her lordship said that they want to use the courts to put themselves on the ballot to be able to contest in the election. So your party disqualifies you, you go to a court in Jigawa State, which has nothing to do with the primaries or the election in Anambra, and you get an order compelling INEC. And INEC says, well, because we're a law-abiding institution, we have to respect this court order. And a court in Imo gives another order, and a court in Anambra gives another order. And it's worrisome. And it makes you wonder, is either the judges have been induced by corruption or they are incompetent? Because when a judge makes an order in a circumstance that should make every judge wary of either venturing into the matter in the first instance or making such an order, then you tell yourself that it's either is a product of corruption or incompetence or both. And usually these orders are granted ex parte without hearing the other side. So what is the urgency? And these judges outside of this, don't ask themselves, why are these people here? We should put them on inquiry. This has nothing to do with this state, because when you talk about courts, you talk about the territorial jurisdiction of courts. So a court in Anambra is not supposed to be talking about an election in Kano State, for instance, or even in neighboring Enugu State. But our judges are gradually descending into infamy, giving a wrong impression to the courts that either the wrong persons are now being appointed to the bench, or they allow politicians to induce them, or they are quick because of some inducement. They make orders that no self-respecting judge would. And despite the NJC giving a code of conduct for judges that even ex parte injunctions should not be granted. Not only are these ex parte injunctions being granted, but are being granted in far-flung places that have no business. And it becomes worrisome when a court makes an order restraining a person, and another court being aware that there's such an order, or at least being or deemed to be aware of it, saying that they're making an order, restoring that person. In other words, sitting on an appeal or vacating an order made by another court of coordinate jurisdiction. And it's worrisome. And it makes you know that the politicians are bringing their desperation to spoil the judicial process. And that was how June 12th election was scuttled. The same courts. And we thought we had gradually recovered from that, trying to, to repair the damaged image of the courts or our judicial officers' involvement in issuing orders that truncate the judicial process, or they bring the courts to disrepute, or make people to lose confidence in the ability of the courts to dispense justice. And here we are again.
Okay, thank you, Mazi. It seems as if I'm the old one out here, Kingsley.
You are protected.
And then Mazi, and of course, Yunus Ustaz, and my colleague Kingsley too are all lawyers. So I think I'll be asking the odd questions according to that. So allow me to do that. Let's face it, he already laid the background. We want to see how, Nigerians will understand this. We feel as if lawyers are doing their job. They are in Akwa Ibom, they are in Cross River, they are in Rivers, they are in Kebbi. And they are issuing, meeting judges and the rest of them about a certain case. And these things have been going on. Here we hear ex parte order, ex parte order. Tell Nigerians, Tietia, are you doing your job really as we may presume outside, or is there something wrong?
Thank you very much. I think there's a whole lot of things that are wrong. Wrong with the legal profession, wrong with the judiciary, wrong with the political landscape. But more importantly, every Nigerian is justified in being confused, because that appears to be the goal. The one thing that is clear is this: we are in the season again for all of this kind of judicial confusion. There are usually a year or two as you approach national elections. That's when you get this kind of anomalies. It's not strange to us, whether it was in 2006 or in 2014. This is what you all get. Even I, as a junior counsel, those days, I have been approached several times to go and obtain orders that are supposed to be clearly contrary to the proper process in court, which is usually termed as abuse of court process.
I'm not cutting you short.
Yes.
Is there a season for seeking justice?
Oh yes. I'm not. Oh, wait a minute. These are political cases. these are all motivated by political, desperation, and to them they consider it expediency. Let me tell you, the thing is this: when you approach elections, politicians become desperate. We don't run a jury system. We run a single judge that makes very significant decisions. So they know the judges. They went to the same primary, secondary school, and probably law school with those judges. And then, let us start with us, the lawyers. It is a matter of serious, gain to a lawyer, either financial gain or professional gain, when a lawyer is able to obtain an impossible order. In Nigeria, we are supposed to, you see, the problem is that of notice. In our law, by virtue of the Evidence Act, every court has judicial notice of every decision that is taken in any other court. Okay. And if you consider the hierarchy of our court systems, the High Court and the High Court of the Federal Capital Territory, together with the Federal High Court, are courts of coordinate jurisdiction. So if one Federal High Court gives an order somewhere in Lagos, a court sitting in Potiskum is already aware of that order. It is by law. The judge cannot pretend that he is not aware. He knows. Naturally. You cannot say that the PDP, a court has issued an interim injunction restraining the PDP chairman, and the court the order comes from Benin, for example, and you say you are in Kebbi and you are not aware. It's a problem. In fact, that judge should be subjected to some criminal investigation. You see, there is a frustration. The Nigerian advocate has mentioned corruption. He didn't hammer it enough. It is because of the corrupt tendencies that is resident in the judiciary, in our judicial officers, that gives the confidence to political players, state actors, to approach them, to say, look, they approach them with state resources, with the kind of money they will never get for all of the years they've been working, together with the money they will get at the retirement benefits. Put all of them together, they will give them 10 times more. Such kind of temptation that the judge cannot resist because they know him. They either approach him through his wife or through his father or through his closest friend, and then because we don't have a jury, they know the judge. So the senior advocate talked about forum shopping. They know the judge, that the man that can deliver this job is here. And then they go to him. Let me tell you something. In 2016, the National Bureau of Statistics, together with support from the UNODC, conducted a corruption perception survey and ranked the Nigeria police as the _1, the most corrupt institution in Nigeria, followed by the judiciary. I was very, very angry with the MBS as the executive director of an NGO, and wrote to the Director General of the MBS threatening it that you are unnecessarily denigrating the Nigerian courts and we will expose this incompetence in data gathering. The Director General of the MBS did not waste time. He compiled, gathered all of the indices with which they reached that conclusion, sent everything to my office, and I followed with an apology.
Oh my God.
Now, in closing, consider again that when we thought the MBS was being unfair to the Nigerian judiciary, in 2020, the Independent Corrupt Practices Commission, ICPC, conducted its own corruption perception survey. This time around, the police became a saint because the Nigerian judiciary became the #1, the most corrupt institution in Nigeria. We're talking about the latest corruption perception index. You know why? Because the perception of the ordinary Nigerian is not about what happens in courts in the FCT or in big courts in Lagos. In smaller courts, whether they are area courts, customary courts, alkali courts, and magistrate court, they know that it is a matter of cash and carry. So when we come to this season where politicians are desperate, where the man says, this is what I want. Who is the judge that can give it to us? Oh, this judge is not loyal. Look for a judge in Kebbi. Look for a judge in Imo. Ask him his price. I think we should say these things clearly. And the frustration, I close with this. The frustration is that you are hardly able to get evidence against these judges. That's why you hear Lawa Akala will accuse the federal high court judge at that time. Say, we knew how you got the $50 million naira to give that injunction. We knew. He couldn't prove it. That was the reason why in 2016, when President Buhari ordered, I can't really prove he ordered, but he holds the responsibility, ordered the invasion of the houses of judges in the night. And then they found heavy amount of dollars that they cannot, justify. So it is a problem. So forum shopping, looking for the judge that can do your bidding, corruption, knowing that there is an attractive element within the judge, and then the worst of it all, political desperation by persons who use resources of state to corrupt our judicial system. Okay. The truth about it is that no matter how stupid, sorry to say, a court order is, whether it's granted in Benin or in Potiskum or in Kafansha or in Oka, you as another judge of coordinate jurisdiction, you are deemed by law to be aware, and you cannot in any way intervene in that matter. But we see senior advocates who, with their pedigree of success and heavy political weight, come to a court and charge heavy money to do an impossible thing, and then they will hail him. Yeah, you were able to stop the party convention. Millions have been used to spend, to organize.
We really have a lot to hear from, much more from you much later in the course of the discussion. Just cool down and pipe down while I can see. Let's hear let's see the perspective, I would say, of Yunus Ustaz Usman about this conflicting, or contradictory court judgment. So what do you think about that? So what do you think about that?
Sir, it is a very dangerous trend. And from my little experience of about 40 years, it normally happens in election and politically related matters in Nigeria, where the issue is that of do or die. That is the beginning. And then my learned brother Silk and my other learned friend had spoken about the judges. But let us begin. No judge will come to you and say, give me money. No. No matter how corrupt he is. We should start in-house. Start from the bar. Mostly it is the senior lawyers who are always used to approach these few corrupt judges. We should blame ourselves first. And the starting point is, like the cases that have happened, should never be swept under the carpet. We start with the lawyers. It is unethical. It contravenes the provisions of Section 1 of the Rules of Professional Ethics. And so, those lawyers must face the wrath of the law. Not the judges alone. No judge, and I say it, no judge, no matter how corrupt, will approach a political candidate or this and say, give me money. No judge will not approach a lawyer and say, tell your client to give me money. Normally, it is the politicians and through lawyers who will approach the judge, and they know which judge is the most corrupt. It is as bad as that. Unless we start from the lawyers, we'll not get anywhere. Let's start from the lawyers. And like the last speaker had said, the money they offer is such an amount of money that normally you have to think of God and the effect on your children before you can reject such money. But then those judges will know that, look, let me tell you, whether you like it or not, whether we say it's political or moral, let me tell you, use 1 kobo out of that money to buy akara, kose, bean cake for your child. Wallahi, in your presence, that child is destroyed forever. I had a very nasty experience in 2019 when the day I didn't have 10,000 naira to buy fuel, I was offered 2 billion to leave a serious political case. I told the man, please, yes, I will do it, but make a very simple promise to me. Say, yes, yes, sir. I say, promise me paradise. He now hissed and dropped the phone. The same politician was the one who later on recommended me to some people. If I had taken such money, would he have recommended me to any other person? And for the politicians, I'm telling you, do you know why most of your children are not doing well? Particularly public office holders. Because you have used wrongful public money to train these children, so that even if you take them to Cambridge or Oxford, God destroys them in your own presence. That when they come back, they become a threat to you. Tell me, let's be practical. This is not a theoretical issue. Let's be practical. Tell me the child of how many past governors or presidents are anything today? Extremely few. Because these people either intentionally or unintentionally had used fraudulent monies to train these children. Why are you destroying your innocent children? Forget about conflicts first. Conflicts or no conflict, if the lawyers and the few judges involved know the effect on them, on their children, on their great-grandchildren, no matter how much, they will not take. And I think we should start taking them to lecture halls. It has come to that. Or take them to pastors and imams. Let them know the effect, the causative effect of this money. It doesn't take you anywhere. Well, when somebody cannot sleep for 5 hours at night, you know something is wrong. Let's start teaching them first.
Thank you very much, Learned Senior Advocate Yunusa Ustaz Usman. We are seeing the intersection there of law and morals. But let's get back to the core issue of conflicting orders. Again, for the benefit of our viewers, the layman would say, look, this is a court order issued by Federal High Court, say in Port Harcourt, and a state high court in Kebbi, or say the Federal Capital Territory High Court has also issued an order. And court orders are supposed to be obeyed. So why are we having this? I know that there are issues framed around this. I'm trying to break it down as much as possible. There is the issue of territoriality, which has been raised. There is the issue of stare decisis, which has been raised, and also the issue of coordinate jurisdiction. Senior Advocate Max Afam, just tell our viewers, when you say courts are of coordinate jurisdiction, what does this mean, and what impact does it then have on conflicting orders?
Well, it means that the courts are of the same rank or ranking. They're on the same level. So none of them is superior to the other, such that the decision of one should override the other one or upturn the decision of the other. So it's not like when a matter moves from High Court or Federal High Court to the Court of Appeal. So if it's Court of Appeal, it's on a higher pedestal than the High Court. But then again, I know you're asking about conflicting order, coordinate jurisdiction, and I thought I should take from what Sept said and let's see the advocate Yunus Ustaz said. Part of the problem is our lawyers. Because if we talk about conflicting decisions, every even any lawyer involved in some of these political matters would have read in the news that the River State High Court has made an order. Indeed, I do not comment as to the propriety of that order, especially it's been made expert, but that it was made. And there may have been challenges to it. And another lawyer wakes up, having heard of it, having known that Secondus has been prevented from presiding as chairman, and the same lawyer rushes to a court in Kebbi. And another lawyer, having heard it, rushes to a court in Cross River. It tells me that our lawyers are no longer keeping faith with what every lawyer is taught in the first year in the university or second year, that a lawyer should not be a tool in the hands of his client to do what he wants. So your client comes to get me an order. I say, no, we can't get an order because there's already an order. We should go to set aside that order. We can't restore you by order from another court. So we are looking more at the money. We no longer care about how people view us. Integrity means nothing. So we can't talk about this like my colleagues have said without really dwelling on the lawyers who also bring these applications. And I will not make any apology for using the word, mislead the courts into giving these orders. And even the courts cannot also pretend to be insulated from being aware that there is already an order. Why make yours when you're not an appellate court? Because he talked about it's about perception. Do the public see the court as a place where you get justice? And it happens every day. We're talking about conflicting court orders. Every day, people are taken to area courts in Abuja very late at night under trumped-up charges of criminal matters. And bail applications are argued. And no rulings are made, or rulings are made denying bail. But on certain arrangements, the same man walks home. Or you be arguing and they tell you that you're speaking English. Because we shouldn't also focus. And these are why people go away, believing that courts have gradually ceased to be places where they get justice.
But Mazi, if I may jump in here a little bit. If a court in Rivers with the court in Kebbi and maybe in Cross River are all at the same level,
Yeah.
and then the court in Rivers gave an order, ex parte order, and then all courts in Nigeria, all lawyers, all judges must know that judgment, because even we, the ordinary people, read it and know that this is what happened in the Rivers in relation to so and so and so person. Why should therefore a person or a judge in Kebbi, for instance, entertain such case without saying that, no, I will take it up, go back now to where the case originated in Rivers, and then vacate it there, instead of having to say, okay, let me vacate it here. I mean, there are procedures, as Kingsley asked.
I agree. That's why I said that for a court outside of Rivers, outside of the judge that made the initial order, to go into it is either a clear case of corruption or incompetence. Because the first question you should address, a court should ask me, a lawyer brings address me as to whether I have jurisdiction to entertain this matter. Or why the rush? Go and put the other man on notice so that I will listen to both of you. What is the exigence? Why are we rushing to give a ruling? And also when that judge cannot pretend not to be aware that there has been an order by that secondus has been, and that's why they say restored. So for it to be restored, it means that somebody has been removed.
Yeah.
For you to make an interim order to restore somebody, what led to the removal or suspension? Why are you assuming jurisdiction? And we are destroying the jurisdiction, the courts. And we are destroying the respect people have for lawyers and judges and the courts. And they see the courts as a place where, as long as you have the money, you can get what you want. And they talked about, they know that they call them friendly judges. So they know the kind of judges that will take the application and grant it ex parte. Despite several Supreme Court decisions that certain political cases are not justiciable, that they have no place in the court. And I think maybe PDP was trying to borrow a leaf from APC, which used the court to remove Oshomole. But must the court be subjected to such ridicule because politicians want to have their way? And it's frightening. Maybe someday people will take canes into the courts and flog the lawyers and the judges out of the courtrooms. Maybe they'll wake up to the reality that people see us as part of as the real big problems in Nigeria after the political class.
Okay. Thank you very much. Back again to Frank Tietie. Again, I mean, I'm trying to place myself in the shoes of a layman in asking this question so that you can explain. Ordinarily, the way our judiciary functions in this part of the world is that there is no ambush. You do not take your opponents by surprise. If Nadabo and I, where Nigerians will say, God forbid, because of our cultural system, if we were to have a dispute, I cannot simply go to court and in his absence, prosecute the matter or seek to diligently prosecute the matter without him being aware of it, and then he having an opportunity to defend himself. So just explain, how this whole idea is to say put the party on notice, and under what circumstances can a matter proceed without the other party being put on notice, which is the ex parte. Just explain that to our viewers.
Thank you very much. You see, the truth about it is that ex parte orders are supposed to be anomalies, because Section 36 of our Constitution emphasizes fair hearing. You must hear the two sides And then the person who is hearing them as a judge must have competence in terms of jurisdiction. Again, you apply ex parte as a matter of discretion of the judge when it sees that there is a sense of urgency and that there would be an irreparable damage, to the extent that if it doesn't preserve the building or preserve the subject matter of the case by granting an ex parte, meaning that he's granting it without hearing the opposing side, there will be trouble and there will be no case for him to adjudicate upon, for him to actually judge. So in order to preserve both the jurisdiction, the integrity of the court, and to preserve that matter, either a thing, physical thing, or an idea that is being sought after as in terms of justice, he needs to make an interim order. It's not an interlocutory order. Interim in the sense that it's for a short time. Normally, by our practice, it doesn't last more than 14 days. Meaning that in these 14 days, it will afford you enough opportunity to go and inform the party affected to come to court and show reason why I should not grant an interlocutory, that is, an interlocutory order, that is, an order that will restrain or compel, pending when I finish hearing the entire matter and I give judgment. That is the idea. So the annoying part, which is very, very, what I think that should make the law visit a lot of punishment on those judges and the lawyers, is that you know that it's an interim order. Instead of going to get a contrary interim order known to you and the judge, when you have the opportunity to approach that same original court that gave the interim order in Port Harcourt, whether you are from any part of the country, even if you are outside the country, to go and apply to join the matter. First, joining the matter to vacate that order, that you cannot leave PDP without a national chairman. After all, he hasn't committed a crime. The facts we are talking about are unfounded. For goodness sake, vacate this order. We don't even want to wait till it is 14 days. We are here 2 days after. Vacate this order now. And the court in Port Harcourt could have done that. But you chose. Because it is a game. You must understand that lawyers are businessmen. And that's why you must excuse them to some extent. They don't earn salary from anywhere. If they don't have cases for 6 months, they go without money, and yet you are supposed to maintain a certain lifestyle. They don't have
such as your bow ties.
They hardly have health insurance. They don't have any form of insurance. They're just there, and then with all sorts of people begging money, hailing them all over the place. Now, if you as a lawyer, the senior advocate has taught me quite a lot in practice. If you as a lawyer, if you refuse to take a matter for which you have been offered 100 billion, you know that you are missing something, because there are 200 more colleagues waiting beside you to jump at it. So you first of all consider yourself highly privileged that of all the thousands of lawyers in Nigeria that have approached me, how can I let myself down? How can I let this client down? Okay, bring the money. Let's see what we can do. The point is this. The lawyer is at liberty to accept any case and do whatever that he's instructed to do. But we're saying that whenever the lawyer does something contrary to the law, because they damn the consequences. I have cases that I'm prosecuting at the Legal Practitioners Privileges Committee at the Supreme Court. I'm standing prosecuting senior advocates. The point is this: it is manifestly clear to the man as a senior advocate that I will damn the consequences. I'll do what my political godfathers have told me to do. After all, who is paying my bill? If I am derobed today, my license is suspended for the next 6 years today, this money I have is able to take me for the next 50 years if I live to that extent with comfortable houses, traveling across the world. We're talking about state money here, state resources. So they damn the consequences. What happens is that you see judges, lawyers who dare themselves and say, and face and say, whatever comes out will face the consequences. And the consequences never come. They never come from the Legal Practitioners Disciplinary Committee. They never come from the Legal Practitioners Privileges Committee. You had how many times have you heard that the senior advocate, with all of these things that learned senior advocate Ustaz has mentioned, that senior lawyers are the ones responsible? How many times has the Legal Practitioners Privileges Committee been able to sanction a senior advocate for offering bribe or for conducting himself in a manner that represents the corruption? You hardly hear that because we need to, they think that they are preserving the integrity of the judiciary or the legal profession, whereas look at the perception report. We are now the most corrupt institution, more corrupt than the police, more corrupt ever. So we are the ones in charge of corruption in Nigeria. But that is the reason why when Justice Mahmood, as chairman of the National Judicial Council, Chief Justice of the Supreme Court, thought he was protecting the judiciary by the slow process with which judges are prosecuted or tried at the NJC. When judges' homes were invaded in 2016, he was embarrassed. So, and I remember in 2016, the fury and the manner with which they were hurrying to save themselves of the embarrassment, but it was too late. Granted, it was illegal of the DSS to have done that, but they were simply playing to the gallery. The DSS knew that Nigerians are aware that this is a corrupt institution and it is nearly impossible to bust it, but let's just do something to expose them. Play to the gallery, even though it was illegal. So if you don't cleanse your own house, whether as a body of lawyers, I'm happy I'm talking to the potential president of the National Bar Association. He knows. And I can vouch for his competence in terms of, straightening up all these things, because he's done it before when he was chairman in Abuja branch, and then he was the national secretary. Unless we get persons to cleanse the audience tables, either in the bar or in the judiciary, we will one day be embarrassed by our own culture. It's just a matter of time.
Frank, really, it's I don't know where to even, how to even couch or rather put the question down to Ustaz Usman. It seems as if the law profession is not what people think it is outside. Ustaz Yunus, given the information we are getting and given how public perception is about the lawyers, forget about the corruption index and the rest of them. People outside always look up to the lawyers and look up to the judiciary in order to get justice, and that's just the bottom line of it. But it seems as if now there are so many serious crises and serious problems in this very sector of Nigerian democracy and Nigerian life. Where do we, or if I should say, how do we get out of this?
Please permit me to comment on what my learned brother Silk had said about saying that where such conflicting orders are given, it is either the judge is incompetent or is corruptible. I think he's trying to be euphemistic. I can never convince anybody that such a judge is not corrupt. It's not because he's incompetent. It's difficult to convince anybody that it's not as a result of corruption. How can anybody who had been appointed a judge, you are not appointed a judge until you at least about 10 years at the bar. How can you, a case you knew happened in the southeast, is brought to you in Bringing Kebi, and you say you do not know that you don't have jurisdiction. It's not anything like incompetence. And it's difficult for anybody to convince me that it is not qualified by financial inducement. That is how far that goes. Let us be practical here. If not, we will not solve this problem. Particularly now that 2023 is coming. If these things continue, Nigeria will collapse. Yes, I'm not pessimistic, but I'm telling you the truth. Because it is particularly the election and election-related matters that we had conflicting judgments in here and there until most of them were corrected by the Supreme Court. If we wait for the same thing in 2023, Nigeria will collapse. Quote me anywhere. Now, coming to your question, sir. Before, during our own time, we used to see lawyers and judges as being next to God. In fact, there was a time in the building I was occupying weekends, people will bring me money to keep for them till the following Monday. But that has stopped. I don't know whether they are now scared of me or so, or because they say lawyers are no longer like before. But unless we go back to that era, the legal profession has lost its name. And if we are not serious, has lost its name forever. Nobody sees a lawyer now as somebody that can be trusted. And the moment that is fixed in the minds of the ordinary people, that is the end of that profession. So something must be done urgently to fix this thing back. It's too unfortunate. The judiciary in particular, the judiciary has always been looked upon as those who will give you what God would give an innocent person. And unless we continue to maintain that, that will be the end of that society too. It is unfortunate that things are not working as we were born into. And unless we go back, it will be terrible. Because let me tell you, once there is justice, if the other two arms of the government, executive and legislative arms, do not exist, the society will still exist. Once there is justice. But once there is no justice, even if the other two exist, the society will not exist. That is how bad it is. And something must be done urgently to rectify this anomaly. It's unfortunate. For those of you there who are young, yes, it is you I pity, because we are not likely going to live to see the end of these things, but it is unfortunate. What about our children and great-grandchildren? Asigwe, I pity you. Asigwe, I pity you.
Eunice, Ustaz Usman, thank you very much. As part of, you just try to see what can be done. There's, again, one phenomenon that I would like our learned guests to explain into our viewers. I know that in a sense they have touched on it by saying, look for a friendly judge. What is called forum shopping. About, again, in conflict of laws, you also heard that, look, a higher court, would frown on that when there is the issue of forum non-convenience. We have seen, for instance, one of the latest, now this is not necessarily a political matter, the Edo State government, through the governor, issued a directive saying that for persons to have access to mass gatherings with effect from the second week of this month, being September, you must show proof of vaccination. That is Edo State. Now, a group went to court to seek an order restraining the Edo State government from enforcing the directive by the state government. Edo State has, there's the state high court in Edo State, there's a federal high court in Edo State, there is the Court of Appeal. Of course, the matter is not on appeal yet. But you would wonder, they went to Port Harcourt in Rivers State. The whole idea of forum non-convenience, assuming the Edo State government were put on notice, they would have to incur the cost of having to travel from Edo State to Port Harcourt to defend that matter. So I'm just asking this question, but Mazi Afamaswigwe, Frank Cheti and Eunice Ustaz, Senior Advocate of Nigeria. Why do we have these issues? You have talked about it earlier. There is an election, a pre-election matter in Anambra. I'm just giving again as an example. And litigants are going to Kano. We don't hear them go much to Meduguri. That would have been very nice to see whether they will sit in Sambisa Forest. Mazi Afam.
It boils down to the same thing we're saying. I wouldn't want to discuss the Edo State matter because it's sub judice in courts. But it worries you why people do certain things. So you're challenging the action of a state government. You go to a different place. Maybe it's because they feel the governor is in control of the courts here and they may not be able to give an order and all that. So people want to go to a place where they feel that the courts will be more amenable to granting their orders. Now, like I said, I do not know about Edo State government. Let me talk about Anambra State, where I also happen to come from. Once it's election season, there's this common saying in Anambra that every politician has his own order in his back pocket. So waiting, if the primary goes this way, the order is never mentioned. If he goes against him, he brings out a court order. And that is why you see them going to different places to get these orders. It doesn't matter whose career is destroyed in the process. If you remember the Justice Ebuebo, Anambra was involved. Justice Nnaji, Anambra politicians were involved. The one at the Court of Appeal, Enugu, Anambra politicians were involved. That there was proven evidence that they gave bribe to justice of the Court of Appeal to give decision in a particular manner. And individuals who were involved in that case are moving about, see politicians contesting for office. Nobody ever prosecuted them. So it seems to be that the attitude in Nigeria is go and sin no more. The judges who have been indicted, even by the NJC, recommended for retirement or dismissal upon credible evidence that they took a bribe and never charged to court. The Court of Appeal decision, I'm forgetting the name of that judge, has created a confusion as to whether NJC can, whether a person, a judge who has been accused of corruption can be prosecuted by the EFCC, despite the decisions of the court that the fact that that if you're being charged with misconduct, that the fact that a matter constitutes a civil matter does not mean that the criminal aspect cannot go on, or the fact that something constitutes a crime does not mean that it cannot bring a civil action. And then we use that as a bar. So if the NJC fails to act, a judge who has been found to be corrupt, nothing happens to him. So we thereby give the impression we are shielding our own. We thereby give the impression that once this matter has slid out of public discourse, we can move on. People are not prosecuted. People are not held accountable. There's lack of accountability. Because if people are held accountable, whether lawyers, judges, or politicians, because sometimes you can follow this money, you can trace the money, how it's moved, either paid into a relations account or something, or either doing a lifestyle audit of the person to know, look, this is your salary, but this is how you're living. You fly first class, your family, your children attend this school where you pay so much from your salary or from your declared earnings, as at this time, there's no way you can support this lifestyle. Even if you have dug a well to hide the money, or you have put the money in a GP tank. But we are not serious about fighting corruption. We care about the optics without starting from the brass tacks, taking it from the proven cases, prosecute this person, get this evidence, make this evidence available to NJC. And Tete, he talked about, someone said people are not being prosecuted. If you do not report a lawyer to the LPDC, LPDC will not do anything. It's not self-activating. They entertain petitions. There must be a petitioner. So if we talk here and nobody petitions anybody to LPPC, nobody gets tried for anything. They can't go fishing for who to try. They will thereby become the accuser, the prosecutor, and the judge. So if the person, just like the senior advocate process, say, this lawyer should not be made the senior advocate. He's so corrupt. He procures court orders. Sorry about that, but in Nigeria now we'll talk about procuring court orders, suggesting something insidious about the manner the order was got. So people no longer say obtained, they say procured. And you see some people derisively referring to court orders as black market injunction, showing you the scant regard people have for the integrity of the orders themselves. Talk less about the process leading to their being granted, or even the person of the judicial officer who granted this order. Mazi. And it worries me a whole lot.
Mazi, there is this argument outside the law quarters that in the case we're talking about, in the case that is now trending, the issue of Uche Secondus, the fault being, or rather if it's a fault in court anyway, whatever it is you call it, having had the order from Rivers and then the judge in Kebbi now goes with a counter order and somebody in Cross River, there should be a body that should be able to discipline that judge or that lawyer who went wrong in the first instance. Now, when we look at that, when you talk about the LPDC, we talk about the NJC, we even can remember the Chief Justice of Nigeria summoning the judges of this state to talk to them about it. Somebody was saying that there cannot be anything the NJC may do without any petition. Has there been any petition against the judges first? Or what are they going to sit down on? Now, if the cases are apparent, we've seen that laws have been floated. Do we require any written petition or whatever in order for the arbitrator, that is, or the person that will just adjudicate over that, work on it? Does that really matter much?
It does, sir. The NJC must receive a petition, which by their rules must be forwarded to the judge complained against for his response.
Even if the case is plain?
What you consider plain may not be legally plain, because that's what is called fair hearing. And under the law and the way the law is applied, the person who is judging you should not be the person accusing you. Because at the NJC, there are people who present this case. So the NJC itself cannot accuse you and judge you. In that case, you can never, whatever decision they give will never be considered as being the right decision. Because when I'm the one accusing you, prosecuting you, and taking decision, the inference is that you can never be innocent. So there must be a petition. The NJC, as we know, is a body that disciplines judicial officers, High Court, Federal High Court, Court of Appeal, Supreme Court. The LPDC, or the Legal Practitioner Disciplinary Committee, does that for all lawyers. Then the LPPC, Legal Practitioner Privileges Committee, hears cases against senior advocates. But they cannot order that their name be struck off the roll or they be suspended. They can only suspend their rank of senior advocate or remove it entirely. But you also see a situation where now people seem to think that the LPDC, Legal Practitioner Disciplinary Committee, no longer has power to discipline the person because he's a senior advocate, because of the LPPC. But LPPC, really, by thinking, should, after hearing any case against the senior advocate, if he makes a fine, should refer it to LPDC to consider whether the person ought to continue practicing as a lawyer. So, yes, in a nutshell, there must be a petition. And the Rule 56.2 of the Rules of Professional Conduct for Legal Practice said, any lawyer who knows that a lawyer has violated provisions of the rules or any duty imposed on him can write a petition. You don't need to be the victim of that circumstance to write a petition. So any lawyer, more like, gives a blanket right to any lawyer who feels strongly about a situation to present a petition.
Okay.
All right. Thank you very much. Gentlemen, we're going to have to take a short break now. When we return, we'll continue with the conversation.
Still watching Good Morning Nigeria. We're reaching you from the NTA. We're discussing contradicting court orders and, of course, the implications of this on Nigeria's democracy. Before we went on break, we were talking about how such cases could just go, without being brought to book per se, if I may use that very phrase. I will now rather want to ask him, because it seems Mazi didn't give me the much I really wanted to hear as a layman. Let me switch over to Tia, and then maybe get his views about this. Most likely move over to Kaduna and get some more. But let me just start with Tia here. This is the situation. You've seen a plain disobedience or disregard to the law and to the ethics and to the rules and procedures. And 1, 2, 3 times it's gone, and then it seems as if nothing can be done because there is no petition per se written to the NJC to act on. And the NJC cannot be, the accuser and, of course, the judge in this case. I mean, I don't think that should be the case. If it is, then maybe it's a hopeless situation.
Well, thank you very much. You see, the senior advocate has said it the way it ought to be as a matter of law. That is, you cannot be both the accuser and the judge. But there is a difference, because that principle was actually further established in the popular case of Ganifa Emi and the LPDC, when the then Attorney General of the Federation was also the chairman of the LPDC. But it's no longer the same. This time around, the president of the NBA, who can only recommend to the LPDC So the LPDC is more independent. So let's extend it by reference. You are saying that EFCC, ICPC, statutory bodies that have been set up to fight corruption, waiting for, with all the budgets they have got, with all the manpower, with everything that they've been equipped with to fight corruption, will now wait, seeing corruption reported in the newspapers everywhere, seeing corruption bear to all Nigerians in the perception indices that we are seeing. And they will say, oh, we can't do anything. We are waiting for a petition to come from Nigeria. Nigerians are, I don't know why they will bring petition. What is this? And they are waiting. And then corruption grows. Is that, you see the analogy? Yeah. You can't, as a responsible body like the National Judicial Council, responsible for, disciplining judges, entertaining complaints against judges, and recommending their removal to the president or to the governor, and then seeing this embarrassing situation facing the legal profession, and then especially the judiciary, and then you say, why hasn't the petition come yet? Let this Chief Justice of the Federation and the chairman of the NJC wait for a petition before he summoned the 6 judges. I mean, the 6 chief judges of the 6 states. Why? He didn't have to. Yeah. Because the truth about it is a matter of responsibility. If you don't do anything, like the Nigerian advocate Ustaz has mentioned, things will collapse, according to somebody, things will just collapse before our very presence. So, responsibility demands that to whom much is given, much is expected. The Chief Justice is perfectly in order by summoning them, even though the effect is a different case. The point is that the ordinary Nigerian we are talking about here, whose interests we are yet to protect, now perceives that, we still have a chief justice that can respond to this situation. I will not belabor myself under certain conditions to now go and write a petition against who? When I'm a lawyer who appears against judges, who appear before judges, who have sympathetic judges all over the places. So you want me to jeopardize my legal practice by going to write a petition against this judge, because I am the foremost Nigerian? No. To whom much is given. You are the Chief Justice of Nigeria. You are the chairman of the National Judicial Council. You are paid salaries. You have budgets to do this thing. You on your own proceed to do it. You don't have to be the one writing the petition. The laws are already there against you. For goodness sake, that you can even instruct the proper agency to bring a complaint before this person. Does not necessarily mean that the principles of fair hearing have been breached. It does not. If we don't do anything like I earlier said, which is the problem with the Justice Mahmood-led NJC and his tenure as Chief Justice of Nigeria. When he waited for petitions to come against these judges, none came. And the DSS had those years, whether they are phone recordings and pictures and videos, the DSS had all of these things. And they said, for goodness sake, NJC, do something. Nobody was doing anything. Lawyers and the Nigerians write petitions. Nobody was writing petitions. Okay, they said, all right, this is a Buhari era. We are busting corruption. We'll show you now that these people are corrupt. And they did what they did. And all of us were further embarrassed. Both the CJN himself, lawyers, and the entirety of Nigeria. We had a greater problem when they invaded the judge's home in the night.
Okay.
They didn't have to do that.
Frank Cheche, thank you very much. Back again to Kaduna Network Center. Senior Advocate Yunus Ustaz Usman. In addition to some of the suggestions that have been made calling for legal sanctions or sanctions by the relevant professional body, what more, in your opinion, can help tackle this problem of conflicting orders with the underlying assumptions that this is often fueled by corruption and therefore it tends to defeat the ends of justice? I'm just wondering, two issues here that I would like to raise. Imitation is a potent form of learning, and human beings, we imitate a lot. Is it possible to begin to insulate the legal profession, if you like, but more particularly the judiciary from the societal rot? Because everywhere you see evidence of unexplained affluence and extravagance and so on and so forth. Is it possible? And can this be achieved, for instance, by training in ethics and otherwise? I know that, I mean, usually this is the vacation season, and from time to time you will hear of training sessions at the National Judicial Institute. But on these critical issues, you've touched on the morality of all of this, but what can be achieved? How to insulate the judiciary from societal roles so that even when the vermin, are coming to pierce that protective aura, judiciary will say, no, we are the custodians of the justice of society next to God.
Yes, sir. Before then, may I just make one comment about whether with or without a petition, the NJC can do something. What the Chief Justice of Nigeria did is perfectly right. He had the power to do so under the third schedule, particularly part 1, paragraph 21, some paragraphs D, E, F, and I. That is, when there is such an issue that you need to act to save the judiciary, you don't necessarily have to wait for a petition to be written. You can start attacking that problem administratively. And that's why the Chief Justice of Nigeria called the 6 chief judges of the states concerned. He's covered under paragraph 21, so paragraphs D, E, F, I of the third schedule to the Constitution. So it is perfect, because if you have to wait, yes, fair hearing, yes. If you have to wait until everything degenerates, there will be nothing again to hear. They have not been denied their right to fair hearing because nobody has now said, look, I'm sentencing you. But he's calling the chief judges. Look, I'm hearing these things, so please, what is happening? He has the right to do so. Now to your question, sir. You see, the issue of how to really insulate the judiciary from these things lies more in moral teachings rather than technical or application of the law. Let them know that, look, these politicians who are using, unfortunately for us, these people are very few. We have over 1 million judges, but those who are doing this are less than 10. So we are still in good shape if we can control it. We are in good shape, believe me. But we need moral teaching, that this money they are giving you, rather than taking you anywhere, destroys you, your children, and great-grandchildren. It is rather a moral issue. And like I've always said, I'm not an imam, I'm not a pastor, but it is my personal experience that unless they are told the evil effect of this money, not on them, not on us who are old, but on our children and great-grandchildren, it's not easy to insulate them, because the Nigerian society is totally crucified in corruption. Crucified because almost, at least, quote me anywhere, at least over 50% of us are involved. So it's not easy to eradicate. But with moral teachings, let us know the evil effect of this money. The money you get, you cannot sleep. You will use it to cure some ailments that you don't know whether it's as a result of the money or something else. I know they are natural ailments, but they are ailments that are brought to you because of the type of money you have collected too. Believe in me or not, I'm telling you. It is rather a moral teaching. Insulating them from the society totally is not possible because they are human beings. They have families. They must have friends. You can't say just do not have a friend. But then with the moral teachings, the judge will say, look, this money you are giving me destroys me rather than helping me. Unless we get to that stage, we won't get out of it. I'm sorry. Before I forget, my learned brother Osigwe, one of the things some people were asking me, even before now, was that was the Chief Justice of Nigeria right in summoning the other Chief Judges and so on? I say yes. By virtue of that third schedule, paragraph 21 in particular, the equivalent of which has been interpreted by the House of Lords in UK, in Gilham and the Minister of Justice, where the Chief Justice of the United Kingdom said, look, we judges are not civil servants, but definitely we are under the service or under the Chief Justice of the United Kingdom. So don't tell me that the Chief Judge of KB or anywhere is not under the Chief Justice of Nigeria. He is. KB or anywhere is not under the Chief Justice of Nigeria. He is.
Insight and perspective on that. And one thing, Mazi, what he said, which still is heartwarming and gladdening, is that we are still in good shape, and that if and only if we can control it. And he even gave a little statistics of maybe not so many of us lawyers are in this, or judges are in this kind of situation, which means if controlled, if we can take necessary steps now, we would be able to at least nip this very problem in the bud. You were the Secretary General of the NBA, and of course, a very staunch member as such. The NBA, frowned at that. We had it shouting in statements and things like that when these things happened, even before the, the CGN announced the ceremony of the judges as a body, as an organization. Yeah. How too bad is the situation to you, and what do you think the body can do, or the association would do, in order to at least arrest the situation? Still, we're in good shape.
Let me just correct an impression before answering your question. I never suggested the Chief Justice of Nigeria had no powers to summon the Chief Judges. He does. What I talked about, your question was, can't the NJC discipline the individual judges since their acts are in the public domain? And my answer to that question was specific, that the NJC needs a petition to act. But if there is a section of their guidance that allow them to take cognizance of things and proceed to trial, I'm not aware of that. But the Chief Justice, of course, can, in discharge of his duty as the head of the judiciary in Nigeria, summon the persons affected who are the chief judges about the goings on in their states to find a way of stemming it, but without pronouncing on on the individual judges involved. Now, the president of the NBA has expressed the feelings or the position of the bar on the recent developments in the bar, which is worrisome. And I believe that he will go on because he's a member of the NJC alongside some other members of the bar representing the bar in the NJC. Even though, unfortunately, the Constitution says that the NBA members shall not be involved, curiously, in issues of discipline of this judge, but the lay members of the NJC can be involved, but not the lawyers. And I wonder the rationale. But the bar can, with the advocacy, condemn it and also engage with the members in the various branches of the states where these things are happening to also find ways of addressing them. And also, I also think you asked for the way the bar. There are short-term and long-term. On the short-term, dealing with the specific cases, having a position presented against persons. But I also think it's time we sat down to really look at the caliber of persons being appointed to the bench. The involvement of politicians in the appointment of judges. The involvement of, well, let him go now. If he doesn't go now, he'll be too old. Of having persons go to the bench as a retirement package who maybe may have failed in practice, and the bench becomes their last option to ensure that they are able to take care of themselves and their family as they proceed to old age. when people, and also figure out an objective way of assessing people who are to be made judges. And even when it comes to elevation to higher courts, from Court of Appeal to Supreme Court, not make it look like a title-taking thing, like the Olubadan kind of system, that if you're the oldest chief, you become the Olubadan. So if you're a PJ, you must automatically go. Or if you're the most senior judge, must become CJ of your state, even when it is obvious that you lack what it takes to lead. So there are things you must rethink. Who gets there? How do they get there? What is the objective test? And this NJC way of interviewing judges that does not give room for interview for up to 2 minutes, has it given us the best? Can there be a written test? Quota system, to what extent has it given us the best that we want? Even if we are to take from states, must we restrict the taking from only those who are shortlisted? Can there be an objective of administering tests so that even those lawyers from private practice who perform very well may go to Court of Appeal or go to any of these courts? Or the objectivity in the appointment, and also making sure that disciplinary process is not such that people will be afraid of complaining. Take to express a sentiment here, take it or leave it. Many lawyers who have genuine reasons to complain are afraid that if they do it, other judges may take it out on them or their clients for complaining, because then you're seen as a snitch. Okay. And so people are cowed into silence. You see things that ought not to happen in a court happen in the matter you're doing, because you don't want trouble, or even your clients tell you leave it, or if you insist, they will get another lawyer.
It's all right.
Okay. Yes. I just, Frank Chete, your closing thoughts on this. If you can, very briefly, where the whole purpose of this conversation is not to suggest to potential litigants who have genuine causes to say, oh, okay, because we don't want to be contributory to conflicting others, therefore I will refrain, from pursuing my rights.
In all of this, the courts still remain the last hope for justice for the common man in Nigeria. There's no alternative to it. What we're trying to do is to improve it. And that's why we are being this. It's like a critique we are doing, not necessarily being critical. I will not miss the opportunity of commenting on the Edo State situation, because we are in the COVID-19 season. And the dreaded Delta variant is on its way, on the third wave. And it happens to be an area where I'm very interested in human rights. And it's very important, because here again, whether it was Justice Kafarati as head of the... Okay, the point is this. Order 2, Rule 1 of the Fundamental Rights Enforcement Procedure Rules state clearly, you can only institute a matter in a place where the human right violation is likely or is being or has been violated. So why are you trying to stifle a lawful order of a governor by going to Port Harcourt when it is clear? And I understand as well. I agree with you on this. It's clear. It's not mine. It's clear. I state the law. So why approach a court in Port Harcourt to stifle a governor in Edo State from carrying out his lawful duties in protecting his people that voted him into power? No. All right. So the point is this. It is as a result of deliberate malfeasance by lawyers to confuse the public. However, the judiciary remains the last hope for justice.
So during vacation, the Court of Appeal in Port Harcourt, Federal High Court overtakes urgent appeals concerning Edo, Delta, Anambra, some of those areas. So this is not the kind of...
There was a vacation court in Edo State,
There is no federal high... I'm talking about... I don't know the subject matter.
I do know the subject matter. It's a human rights matter, sir.
But then again, on human rights, has the Edo State government provided enough vaccine for people to take before bringing the order?
The issue is that why restrain the governor from carrying out his lawful duties in protecting millions of Edo people because of an application of one person in Port Harcourt? Let us look at these things. It's a matter of life and death, and so we cannot use the law as an instrument of confusion and thereby preventing public officers from carrying out their duties. And, mind you, it's a public health issue.
Gentlemen, we must say that this argument or this conversation will keep going on and on. Let's keep it for another day. We thank you so much. Frank Tete, human rights lawyer and executive director, Citizens Advocacy for Social and Economic Rights. It's our pleasure being part of Good Morning today.
Thank you so much.
Something goes to Mazi Afamasigwe, former Secretary General of NBA. It's our pleasure.
Thank you.
We thank you so much, Yunus Ustaz Usman, Senior Advocate of Nigeria. Your perspectives have been very, very, very important to us and very nice to hear. Thank you so much for being part of this program this morning. Let's take sports before we round up.
Nigerian football may have improved in recent years, but there is still much to do in the league to ensure it meets global standards, much of which former Super Eagles captain Austin Jeje Okocha attributes to funding.
We all know that it's not the best league in the world, but we hope that things can get better, and things can only get better if we have more financial support, in our league, and for me it's clear that football is all about money now. It's big business, and we just have to find a way, to structure our league in a better form so that it will become more attractive for the corporates to invest.
The Nigerian football legend also wants the private sector to be more involved in developing the game in the country.
We should find a way also to take government off our football, because I don't think that this should be part of our football administration, so if we can get corporates to take over our football, I think our league will be more competitive.
Once this is done, the former Bolton Wanderers star is optimistic that Nigerian football will compete favorably with others across the world.
All right, so that's it for us on Good Morning Nigeria today. Thank you for being with us. The program returns tomorrow, 7 in the morning. I'm Kingsley Osadolo.
And I'm Yusuf Nadabu Usman. Bye-bye.